What are the potential fines and charges for a hit and run in Ontario? There are two pieces of legislation in the Highway Traffic Act that are used to enforce that type of behavior. One is under Section 199(1), called failure to report an accident, and the other is under Section 201 of the Highway Traffic Act, calling it failing to remain at an accident. Under Section 199(1), those charges are indeed less than a failing to remain, but they are certainly not a minor charge if you're facing one. If you are charged with that, you'll see one of two things. You might see a ticket with a fine on it of $110, which is an out-of-court settlement, and with that it will come with 3 demerit points. So that's a ticket. The other way you would see a charge like that is if the officer decided, based on the severity of what happened, they may decide that they would like to summons you and bring you before a court. If that happens, the court has the ability to select within a range of fines up to $1,000. The second way that a hit and run would be dealt with in Ontario is by using the Section 201, which is failing to remain. Failing to remain is considered, has been argued to be one of the most serious charges under the Highway Traffic Act for a variety of reasons. It's only issued by summons, and when it's only issued by summons, we know one thing, that the officer who had done the investigation considers this to be significant, considers it to be serious, and wants this before a judge or justice of the peace for the court to determine the amount of fine. The court will look at the situation and find out how aggravating it might be, and the fine, if convicted, is up to $2,000.